In this video, we will discuss Supreme Court of India. The Supreme Court of India was inaugurated on January 28, 1950. It succeeded the Federal Court of India established under the Government of India Act 1935. Article 124 to 147 in Part V of the Constitution deal with various provisions of Supreme Court. Stands are the effects of the judicial system of India. It consists of Chief Justice and 30 other judges. How judges are appointed. Honorable Supreme Court of India on October 16, 2015 quashed the National Judicial Appointment System Act and declared the 19th Amendment to replace the collegium system of appointment of judges to the Supreme Court as unconstitutional. In the process, it reinstated the erstwhile collegium system for the appointment of judges through inviting suggestions to improve the credibility of the system. Under the collegium system, the seniormost judges of the Supreme Court is appointed as Chief Justice of India. Other judges are appointed by President after consultation with the Chief Justice and other such judges of the Supreme Court and of the High Courts as the President may deem necessary. In a landmark judgment, the Supreme Court in Supreme Court Advocates on Record Association versus Union of India case 1993 held that the Chief Justice opinion in the appointment of judges of the Supreme Court and in the appointment and transfer of the judges of the High Court shall enjoy primacy. Additionally, the Chief Justice should consult a collegium of 4 senior-most judges of Supreme Court in this matter. Next, the qualification of judges. The judges must be citizen of India, have been a judge of a High Court or High Courts in succession for 5 years, or an advocate of High Court or High Courts in succession for 10 years minimum, or in President's view, a distinguished jurist of the country. The Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. How judges can be removed. A motion seeking the removal of the judges can be presented before either house of the parliament. If it is to be introduced in the Lok Sabha, it should be signed in by not less than 100 members of the Lok Sabha. If it is to be introduced in the Rajya Sabha, the motion should be signed in by not less than 50 members. The resolution should be supported by a majority of total membership of both the houses and by a 2/3 majority of the members present or voting. The grounds of removal are 2. Proved misbehavior or incapacity. The Judges Inquiry Act 1968 regulates the procedure relating to removal of a judge of Supreme Court. A removal motion signed by 100 members in case of Lok Sabha or 50 members in case of Rajya Sabha is to be given to Speaker or Chairman. The Speaker or Chairman may admit the motion or refuse to admit it. If it is admitted, then Speaker or Chairman is to constitute a 3-member committee to investigate into charges. The committee should consist of the Chief Justice or a judge of the Supreme Court, a Chief Justice of a High Court, a distinguished jurist. 5th, if the committee finds the judges to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. Next, after the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judges. Finally, the President passed an order removing the judges. It is interesting to know that no justice of the Supreme Court has been impeached so far. The first and the only case of impeachment is that of the Justice B. Ramaswamy of the Supreme Court from 1991 to 1993. Though the inquiry committee found him guilty of misbehavior, he could not be removed as the impeachment motion was defeated in the Lok Sabha. Thank you all.